Congress is getting ready to go to war with President Obama over his executive actions on immigration. The House setting the stage for a possible Supreme Court battle. President Obama's power grabs and use of executive action is also a controversy out on the campaign trail this year.
Executive power, as we all know, has been the preferred vehicle of President Obama, abusing his authority.
He just signs executive orders all over the place. Then he'll be sued on that. He'll be out on a golf course in about 3 years when it comes up.
Since he's given up on working with Congress, he thinks he can impose anything he wants. He's not a king. He's a president.
I will rescind every single illegal and unconstitutional executive action Barack Obama has done. That means on day one, his illegal executive amnesty goes away with the strike of a pen.
Back on Capitol Hill, today's vote authorizing the Speaker of the House, Paul Ryan, to file a brief and thus joining in an already filed case that challenges the president's plan to shield 11 million illegal immigrants from deportation. South Carolina Congressman and lawyer Trey Gowdy goes on the record. Good evening, sir.
Good evening. How are you?
Very well. Does this mean anything to a judge that the House of Representatives may be filing a brief saying "Me Too" on this lawsuit brought by states against this executive action?
You know, ordinarily, I don't think amicus briefs mean that. I mean, judges will never tell you that, but I don't know that judges are that persuaded by amicus briefs. I think this may be a slight exception because this is a constitutional question, and the House definitely has standing. I think we would have had standing to bring the suit, quite frankly, but the states brought it. I would think the Supreme Court would be interested in our perspective on the constitutional equilibrium.
And when will this be filed, likely?
As soon as we can find a lawyer smart enough to draft the brief for us, and that rules out most members of Congress. So I think the resolution allows Paul, if he wants to seek the advice of outside counsel.
You know, I don't get into the weeds, but it is sort of interesting because you might not be able to bring this yourself, having not what's called standing, but it's sort of interesting is that with somebody else's, you can weigh in sort of saying, this is how we feel. So it does sort of let you get in the back door to be heard on this.
Well, you know, you have to have an injury to have standing, and I would argue that there was an institutional injury. Keep in mind, the Congress affirmatively said no to DACA. You may like that position, you may not, but Congress did weigh in. So you could argue that our institution has suffered an injury under Raines versus Byrd, but there's no question the states have suffered an injury, particularly when you are asking them to reconfigure their driver's license paradigms and apparatuses. So I think we did have an injury, but it's moot because the states filed the suit.
All right, let me go over to the other side of the hill to your brother chamber, or sister chamber. The Republicans on the Senate say that they will not hold a hearing. If it were your decision, would there be a hearing for the Supreme Court nominee, Judge Garland?
Well, thank the Lord, it'll never be my hearing because I can't sleep sitting up in a chair, so I'll never be in the United States Senate. But no, I would not. I would meet with the nominee because I think that's the respectful thing to do, and he's a very accomplished judge, so of course you're going to meet with him. But the reality is, Greta, elections have consequences, and yes, the president won in 2012, and yes, the voters in 2014 fired Harry Reid and replaced him with a majority in the Senate. We are 10 months away from an election, and if you'll keep in mind, whenever there's been a vacancy in the past, the president and Democrats have always said we have to keep this jurisprudential equilibrium. You have to replace a progressive with a progressive, a moderate with a moderate. Scalia was the most conservative judge on that court. So if you're going to keep that equilibrium, you need to go find the second most conservative person in the country and replace Scalia with him or her, and this judge would not be the second most conservative person.
Well, I'll leave you with most of the last word, but I don't know, this equilibrium stuff isn't in the Constitution. I think the president gets to choose who he wants, and the Senate gets to advise and consent. But anyway, I'm going to sneak in the last word. Congressman, thank you for joining us.
Yes, ma'am. Thank you.